Good morning, and may it please the Court. I'm Alexander Klein with Barquette, Epstein, Kieran, Aldea, and Laturco on behalf of the appellant.
If you could just speak up a little bit, please.
Sure.
Thank you.
Is that better?
I think so. Thank you.
Thank you. The school in this case decided the administrative proceedings on the basis of affirmative consent. So let's talk about affirmative consent. This is a case
So let's clarify then. Alcoholism capacity is not an issue.
Correct.
And they conceded that in their brief.
Correct.
Thank you. You may proceed.
The school decided this case on the basis of affirmative consent. So let's talk about affirmative consent. This is a case where one student begged the other student to engage in sexual activity, where that same student overcame the counterparty's protestations of no, we shouldn't. A student who gave and received oral sex assumed a dominant position in sexual intercourse, which took place in that student's own car, where during the course of that intercourse, that student admitted that she was on top and mounting the other. The student that I'm describing, that I'm representing, is not the perpetrator of those behaviors. My client is the student who succumbed to those behaviors. And yet, pursuant to an administrative proceedings at the Stony Brook University, my client was held not to have engaged in sexual activity with a counterparty who was too intoxicated to consent or who was incapacitated, but a student who did not provide affirmative consent to the sexual activity that she instigated, promoted, continued, and hosted.
So I just want to clarify, because you know the standard that we have to follow, correct?
Of course.
So with respect to the evidence that was presented, I'm concerned also about some text messages. You have something on R228. In the middle of the page, it starts at 4:52 a.m., and then you have 2:29 at 2:52 p.m. I hope you're okay. So I'm concerned about that information. I'm also concerned about the testimony that was initially given by her friend, which is on R226, that they use a condom was not used for one of the encounters. So we have an encounter in the woods, and another encounter in the car. You have her friend who says she wasn't drunk when she picked her up afterwards. And then Mr. A, another witness who spoke initially, said that she threw up in the car. She fell asleep in the car and woke up to someone, I won't use the word, engaging in sexual relations with her, and that she threw up and that someone put something in her drink. And then you have issues with her friend being the one who wouldn't consent. And she said in her report she was ready for things to escalate. Is there consent for the woods and not consent for the car? I'm trying to understand where we're going with this.
Sure, Your Honor. And I think that it's helpful to take all of those points and break them down into what's relevant to affirmative consent versus what's relevant to incapacitation. The student who became the complainant, actually not the complainant, her friend was the complainant, but on her behalf, stated that she had passed out during the course of intercourse, stated that she had consumed a lot of alcohol. There were allegations that maybe she thought that someone had spiked her drink. None of that is relevant to whether she provided affirmative consent. What it's relevant toward is whether affirmative consent that she provided was vitiated through the existence of incapacitation, which is an entirely separate standard, as you know. The standard for incapacitation, which was not found by the school, is extremely high, and it requires that essentially you lack the ability to knowingly choose to engage in sexual activity.
Counsel, if I could just interject for a moment. So when you say that the school did not find incapacity, are you referring to the original review panel's determination?
Yes, Your Honor.
There's also, though, then the appeals committee's determination, the operative order here that is being challenged. So the appeals committee, in their determination dated March 31st, 2020, seems to expressly find that there was an inability to consent based on their review of the evidence. At page 193 is that determination. So
But I want to focus, I understand what was said, but I need to focus on what was listed in the briefs. So let us be clear about this. The respondent's brief, page 38, as all parties agree, the review panel concluded that PC had committed sexual misconduct against SG, regardless of whether SG was or was not incapacitated by alcohol. Thus, arguments about whether the university should or should not have found SG incapacitated are not properly before the court. I just want to make sure we focus on what the argument is here today.
Yes, Your Honor. And I would note that the appeals board also held that they were not disturbing the findings of the school's finding of the school. I think what realistically took place before this school is that this is an entire case based upon incapacitation. This is a student who did not allege that she never provided affirmative consent, who said, I was too intoxicated to consent. This is a case where all of the evidence that was marshaled pertained to whether she was too intoxicated to consent. It's a case where the notice of charges that were given to my client did not say anything but this: you are charged with engaging in sexual activity with someone who's incapacitated. In particular, stating, quote, this is at the record at 215, it is alleged that you engaged in sexual contact with a female student while she was incapacitated due to alcohol and unable to give consent. Those are the allegations in the notice of charges against him. And I think properly the school is arguing that they can't argue that he was found to have been that the student was found to have been incapacitated and therefore unable to give consent, because that's not what was found by the school during the proceedings. You mentioned, Your Honor, Judge Iannacci, about text messages that you were concerned by. The text messages in issue show that my client was guilty, felt guilty to a friend that he had made a promise to, that he was going to essentially look after this counterpart who he was hanging out with that night, and that he would not engage in sexual activity with her, and that it would remain platonic. He then left, walked into the woods with her, and it's there where my client's counterpart said, he kept saying it would be a bad idea, and I kept saying it would be fine. That's at R29.
And then when she said that she doesn't own my body, or
She goes on to say, student 2, I've referred to as the friend in my brief, who had said, don't engage in this behavior. Well, that student, quote, does not get to control my body. That's also the same page. She says, quote, he kept talking about how much we shouldn't do anything. She says she didn't remember who initiated, but, quote, I remember at the moment being okay with everything that could happen. This is what affirmative consent is made of. This is extremely unusual to have a quote-unquote victim in a case like this making admissions as to the affirmative consent that she provided over and over and over again throughout the night. This would be a different case if there were a finding that she had been too incapacitated to consent. It would
or as in the Hay case, he locked her in the room.
Completely different. This case is solely decided on the basis of affirmative consent, and I would challenge the panel to have any other case that's been brought before it where there is more evidence of affirmative consent from the word of the victim herself, who said over and over again that she consented but regretted it, that she was too intoxicated, that she wouldn't. I'm sure the state will mention that during the course of sexual activity there was an act of choking. She never says that she didn't consent to the choking. She says she wouldn't have consented if she were sober.
And then
Oh,
he
how-
also said in his statement, when he talked about hurting her, he meant not hurting her feelings, not physically hurting her. That's on R-143.
Correct, and even after the choking incident, what I think is critical and may have been lost in the briefing, the choking incident occurs during the second act of sexual activity, which is in the woods, part 2. After leaving the woods, when this alleged choking incident occurred, she then hosts my client over to her car, which he had never seen before and couldn't have known where it was unless she had told him, where they were obviously, they had already had sexual activity in the woods for a long time.
Video just shows that he gets into the passenger side of the vehicle. He gets into the driver's side front seat, closes the door, then gets into the back seat.
Which is metaphorical for the night in question, that she was in the driver's seat this night. She was the one who, had it not been for her, there would have been no sexual activity. She is the one who, had it not been for her, they would not have had sexual intercourse in her car. He wouldn't have known where her car was. She is the one who told him when he went into the 7-Eleven to buy her more alcohol that she wanted, to go back and get a condom, which he didn't buy.
Okay, so counsel, how is it that if we were to agree with you that we would not be in violation of the Court of Appeals decision in the Hague case, which basically said it's not up to us to do evidence finding, and there might be substantial evidence on either side, but that doesn't mean that we find in the respondent's favor. So how do you?
What's interesting
address
about Hague is that it doesn't stand for any grand new proposition of law. It's just an extremely close case where it goes all the way up to the New York Court of Appeals, and there's a dissent. And over the dissent, it's found that on this very close call, that under those circumstances of that case, where a student had been locked in the room, that the sexual activity rose to the level of a plausible violation, plausible enough to sustain the school's finding. But here's what's different.
But nevertheless, we are not supposed to engage in evidence finding.
Right.
So how is it that what you are laying out is not evidence finding?
Well, 2 points I would make, Your Honor. One is that the Hague case was decided under the simple threshold of substantial evidence. And of course, part of our application today is that there was not substantial evidence of a lack of affirmative consent. In fact, there was no substantial evidence of it, and to the contrary, there is overwhelming evidence that she did consent. But moving that to the side for a moment, the school itself elevates its standard beyond substantial evidence to a preponderance. And in a preponderance, it is not true that you can have two equally plausible evidentiary bases for a finding. Instead, under a preponderance of the evidence, it has to be more likely true than not.
That's in the student code.
Exactly, and you did not have that in Hague, but you have that under the school's own policies here. And on an Article 78 review, this panel has the ability to determine that in making a finding that was respectfully, clearly not based upon a preponderance of the evidence of a lack of affirmative consent, this panel has the ability to say that it did not abide by the school's own policies and procedures in doing so, which, as a matter of law, constitutes an arbitrary and capricious finding. So whether it is because the decision was arbitrary and capricious for violating the school's policies in that regard, or because, truthfully, there is not substantial evidence or really any evidence that she withheld her affirmative consent, the school's findings should be reversed. I would note that the relief that we're requesting is not a finding that our client goes away and this is over, simply that the finding be vacated and there be a new proceeding so that there can be a submission of evidence and an evaluation of the evidence that's actually presented.
Okay, so I have another question, and that is, do you believe that the review panel engaged in burden shifting?
Absolutely, Your Honor.
And in what way?
So one example is this allegation of choking. There is an allegation that my client engaged in an act of sexual choking while they were in the woods. And there was a notation in the decision about the choking that he essentially failed to identify when there was affirmative consent for that act.
Mm-hmm.
It is not my client's burden to demonstrate affirmative consent for an act. He can sit at a table and do absolutely nothing, just like a criminal defendant could. Because under the school's policy...
Yeah, based on the school code with regard to this. Okay.
Absolutely. And so it rather than him having a burden to say this is when there was affirmative consent, it is the burden on the school or the accuser to say, here's why there was not affirmative consent. And what's notable is there really was evidence of affirmative consent, even to the most, the ugliest components of this act. After that round 2 of sexual activity, which included that incident, they left and went into her car where she mounted him, and they engaged in intercourse.
And also oral intercourse.
And performed oral sex on him, which all of this, by the way, comes from her.
But what about the moment or second that she was blacked out? Was she able to give affirmative consent at that point?
If it were true that she was blacked out during this sexual intercourse, then no, that would not be something where there could be affirmative consent, but not because there was never affirmative consent provided, but because affirmative consent becomes vitiated at that moment.
So what about
that's not what this school decided. If that
Excuse me? What?
That's not what the school held. The school didn't say there was no affirmative consent because it was vitiated through incapacitation. Instead, it explicitly said, we are not making a finding as to incapacitation, which, for what it's worth, and that's not much, there was a lot of evidence that she was not incapacitated to the extent that she claimed, including her own lucid text messages immediately after the incident, going to see a friend within 1 hour of the incident who said...
But that really seems to be evidence finding. And that seems to be engaging in evidence finding.
It's honestly a side...
Whether you agree with Haig or not, it is the Court of Appeals. And whether they were reviewing a close case or not, they've still chastised the appellate courts, the appellate division courts, not to engage in evidence finding.
Except that on an Article 78 case like this one, or like any Article 78 case before the court, one of the standards for the court to consider is whether the finding by the administrative body was supported by substantial evidence. Mm-hmm. So there is some component of your responsibility in this case to do just that, which is to evaluate, not weighing close calls in the evidence, but to evaluate yes or no. Was there substantial evidence that this student withheld affirmative consent from my client to engage in the events of this night, in events that she herself says she instigated, hosted, and dominated?
So, counsel, substantial evidence is... The standard is that of a reasonable person. So it is whether or not the review panel, the appeals committee, whether their review of the evidence, whether it's reasonable, not whether I think or we think that it was a reasonable determination, but whether it is a reasonable conclusion based on the evidence that is presented. So your argument is almost that we would have to find as a matter of law that the complainant's testimony was incredible. They found that the testimony was credible and consistent over time, given the evidence that was presented.
To the contrary, we would ask that the complainant's testimony be credited almost entirely. Her testimony is what the case is built on, which is that she provided affirmative consent, that she instigated the sex when my client said no, that she told my client to go and get a condom, that she hosted the sex in her car, that she mounted him during this, and that all the while, particularly in her quotations that I recited before, my client is saying no.
But the testimony was also that she was passed out in the car, and that according to the complainant, that when she asked this PC about it, that he indicated, oh, that you were just out for a second or a moment.
Correct.
So there's that testimony too.
There is. And if you credit that testimony, or if the school credited that testimony, they would have had the right to, I don't want to waive any arguments, but to argue that there had been incapacitation and to enter a finding as to that basis. But that's not what they did. This case is not about incapacitation. There's no way that, this court hasn't seen the witnesses testify. The hearing in this case took place very quickly after the incident in question. They had the benefit of being able to see the expressions on the witnesses' faces, and they, despite the fact that the entire case was geared up toward what Your Honor is describing, this question of did she pass out, was there incapacitation, they declined to decide the case on that basis. The case should be remanded for a new hearing where they would be able to decide that issue if they wanted to. But ultimately, I agree, Your Honor, the substantial evidence, which is not the only standard in place here because the school raised it up to preponderance, but even under a substantial evidence threshold, the question is whether there's such relevant proof as a reasonable mind may accept as adequate to support a conclusion. I would offer this court that there is not one scintilla of evidence that there was a withholding of affirmative consent as distinguished from incapacitation.
And the definition of affirmative consent, we know.
To support the conclusion that was rendered here. Thank you very much.
Thank you.
Good afternoon, Elizabeth Brody for the university. The hearing panel's unanimous determination finding the petitioner responsible for sexual misconduct and suspending him for 18 months was supported by substantial evidence. Evidence that the petitioner had sex with the complainant after she lost consciousness, and evidence that the petitioner choked the complainant during sex alone provide ample evidence to support the charges of sexual harassment, non-consensual sexual contact, and non-consensual sexual intercourse. Affirmative consent requires words or actions giving, quote, clear permission for sexual activity, and consent is revoked automatically, this is in the student code record at page 55, by, among other things, quote, physical resistance and, quote, losing consciousness. The panel reasonably found...
Didn't she say that she wasn't out at some point? She said she wasn't really out. It felt like she was asleep, but she wasn't really out.
That is not in the record. All of the available evidence in the record...
I read the record.
All of the available evidence in the record is that she lost consciousness. She asked the petitioner, was I out? He said no. She said it really felt like I was, or was I? She asked him a second time. He said, oh, you were only out for a second.
It only happened in the car. Then the woods, that was okay. She agreed to that.
Yes, and the hearing panel's report doesn't focus on that part of the evening. The hearing panel's conclusions, if you read their decision, are focused on the choking, the sex in the car, the loss of consciousness.
So what about the appellant's argument that this is not based upon her incapacity, but rather affirmative consent?
We agree with that, as we said.
So if you agree with that, then how is it that if she was passed out for a moment or a second in the car and not able to give, incapacitated so that she couldn't give consent, how does that work?
So on page 55 of the record, which is the student code, they define affirmative consent, and there are several conditions that are then given on affirmative consent. So for example, it can't be the result of coercion. That's independent. That's independent of incapacitation. Incapacitation on alcohol or some other basis is another ground that you can't give consent. And then it says that consent
Can you just point out to where in the appeals decision it talks about her passing out? Specifically, it was alleged that you engaged in the following behavior: touched the breast and genital complainant in the woods and in the vehicle, oral sex, spat in the mouth, choked, penetrated, and then with a condom and without the condom. I don't see anything about passing out in this.
Well, I was discussing the findings on page 344 and 345, and I know certain
I'm
materials.
reading the appeal decision.
So 194 of the record. It says it on the top of the page. Next page.
So the appeals decision, again, as opposing counsel
He's referring to.
stated, did not disturb the findings of the hearing panel and simply states we affirm, and then focuses on the particular arguments that he raised on appeal, which again were largely focused on incapacitation. But the discussion of her passing out comes from the hearing panel's decision, where they summarize the evidence, stating that, I felt as if I passed out. I woke up from being asleep, and then he told me, quote, told me I was, quote,
Where are
only
you
out for a second.
referring to so we can see what it is you...
So I am at page 344 to 345 of the record, which is the hearing panel's decision. It's pages 2 and 3 of the hearing panel's decision.
Wait, page 3?
344 and 345.
Okay, so you're going to the original determination?
That's correct. The appeals decision, again, as
On 366 is the appeals decision.
right, and the appeals decision does not re-summarize all of the findings of the hearing panel. It adopts them, and then its substantive analysis. As part of the record, he submitted the brief that he submitted to the appeals committee, and that brief urged the appeals committee to overturn the decision because he claimed she was not credible.
What are we deciding, though, the appeals decision?
Well, the appeals decision adopts the findings of the hearing panel. So although it doesn't, it adopts those decisions. So I respectfully submit that we should reference the findings the factual findings that it adopted without re-summarizing. The bulk of the appeals decision is, the bulk of the analysis in the appeals decision is directed at rebutting the arguments that he raised in his brief to the appeals committee, which were focused on you shouldn't credit her testimony because the video evidence showed that she wasn't intoxicated. She's not credible, and so that's what the analysis in the appeals decision is. But it does, as opposing counsel agreed, not overturn. It accepts the findings of the hearing committee.
Okay, but the problem is that the appeal panel basically said they weren't dealing with the issue of incapacity. I mean, so that's not the issue here. So then how do we go back into this non-consensual sexual contact as part of the original panel, which seems to be deciding some of these things based on her intoxication?
There's nothing that was decided based on her intoxication. So, for example, let's just jump to the loss of consciousness.
Well,
even if
the complainant stated in the investigative report and in the hearing that she did not want the respondent to choke her during sexual intercourse and that she would not have allowed that to happen if she were not intoxicated. So that's the basis of this determination.
well,
So now we're supposed to say, well, it doesn't really matter because they found that she didn't give consent, but how did she not give consent?
Well,
Because she was intoxicated.
there was evidence, and there's no evidence in the record that she did give consent to the choking. Her statement to the investigator during the Title IX investigation was, I never would have consented to that. I never would have consented to that behavior. She also
I wasn't
explained
intoxicated.
but she never said, I did consent to it, and she...
The whole thing, when you speak to us, because all of us spent a lot of time reviewing this record, in and out. So we're aware of what was said and what was done. No one is minimizing the importance of this, but you need to, when you're saying something to us, Say it in totality, please.
So she said, I never would have consented to being choked if I weren't intoxicated. She also said that she physically attempted to pry his hands off of her neck, which, again, physical resistance is automatically revoking affirmative consent, and he continued to choke her after that.
In the woods.
Yeah, I was just about to say that. That was in the woods. So then she goes from the woods and they go off and buy condoms. I mean, that's, where do we go from there?
So the purchase of condoms happened before the choking, and then...
Oh, it did. Okay, so, but then they go to the car in the parking lot.
It is undisputed that they walked to the car, but that is not evidence of affirmative consent. In matter of
Why did
Weber
she
v.
get in the
SUNY
back
Courtland...
seat of the car? I mean, really, let's take this, like, at what point?
Well, there was evidence. There was the review panel heard
The video shows her opening the door. We all watched it.
Yes.
She closed the front door and got into the back seat with him. And she said that she sat on his lap and they engaged in oral sex.
So respectfully, the standard for affirmative consent is clear permission, and in matter of
Or by
faith-
acts.
Or by acts.
Your
that's
definition is
absolutely
very clear.
Absolutely.
And it's a preponderance based upon Stony Brook's code of conduct.
Absolutely. And I want to point out a couple of things. So a lot has been made of the fact that she mounted or straddled him, but that was the same set of facts in matter of Hogg. It's not. It's in the.
Hogg, he locked her in the room.
Okay, but I just if to the extent
Hogg he locked her in the room. This person walked. You see the gate. You see them walking to her car. She had the key to unlock her car. She knew where her car was.
she did. You also see in the video
And
his
then an
arm
hour
around.
later, her friend picked her up and said she wasn't drunk.
So these are.
And then she told Mr. S.A. that she woke up, something terrible happened, and she woke up in her car and someone was doing something inappropriately to her.
Yes. Yes, that's correct, and that would support the hearing committee's determination that sexual intercourse occurred without affirmative consent. With respect to walking to the car, the review panel heard testimony that the complainant did not want to have sex in her car because she was afraid of people seeing them, and I would direct you to the matter of Weber v. SUNY Courtland case, 150-83rd at 1430. It's also in our brief, and that's a case where two individuals had sex, oral sex, on a playground, and then the man asked, do you want to come back to my apartment to have sex? She said no. They went anyway. It was found that that was not affirmative consent. There's no evidence that she verbally at any point consented to sex in the car.
You don't need verbal, though, according to your
correct.
definition.
Absolutely, you don't need verbal.
Your
And so,
definition, though, we're constrained by your definition in your code of conduct.
I understand, Your Honor, and I will address the by actions implication, but I just want to establish that, she
And
said.
again, you have two, maybe three separate. You have before 7-Eleven in the park, after 7-Eleven in the park, and the car.
Yes, that's correct.
3 times.
That's correct. And so while they're walking to the car, again, there's no evidence of any verbal, and the statement of her is
Why
that.
didn't she just walk to her dorm room?
I really can't answer that. And a lot of the facts in these cases are very
fact sensitive.
and they're very complicated. The video shows
That's why
him.
we have to get it right, counselor.
I appreciate that. And I'm trying to direct you to the evidence that the hearing panel reviewed that supports their substantial evidence determination. So when they're walking to the car, for example, you can see in the video his arm is around her neck, walking her to the car. I think that would support the hearing panel's determination that there was not, quote, clear permission to go to the car.
But she said that she didn't really want to do that. She didn't want to have sex in the car because, it was public, et cetera. But she, quote, caved. She caved.
Yes, and affirmative consent can't be the result of being pressured and pressured and pressured until you cave.
Wait a minute. Wait a minute.
Knowing permission.
Wait a minute. You're going to talk about pressure, but we have the 2 incidents that have already occurred. And who was pressuring who initially?
Initially, certainly, he never brought a Title IX complaint, and
But the point is that if you want to say there was pressure, you do have to look at the fact that she initially pressured him, okay? Understandable, separate event, okay? Then we have the second event. Now we have the third event. He wants to go to the car, and she, quote, caved. That sounds like she consented to me. She caved. Okay, so she goes to the car. She opens the door, opens both doors, actually, right? With the key.
Yes, after on the video, he gestures like, is this your car? I mean, I think that is, there's no doubt the sexual intercourse occurred. And like
Okay,
in
so
Haug,
now-
there's no doubt that she mounted him, and there may be no doubt that there was oral sex.
But doesn't
given and
that
received.
show affirmative consent if she mounted him?
Well, in Haug, that was not evidence of affirmative.
Excuse me?
In Haug, in the Court of Appeals case, that same thing occurred, and that was not evidence of.
Haug, he locked her in the room. Please, you must be very specific. This is fact specific. At Haug, he locked the door of her dorm room.
I was merely pointing out that evidence.
You have to point out the fact that she was locked in her room. That confinement, that inability to get out. She went into her own vehicle. She had the keys to her car.
She did. But again, in Weber, there's evidence that the complainant walks from the playground where they exchange oral sex to his house, and that is not evidence of affirmative consent. There are similar fact patterns in these cases, but the fact remains that while he was choking her, she physically attempted to pry his hands from her neck, that she lost consciousness during
I guess
sex.
my question is the chain somehow broken by virtue of the fact that she continued to have sexual acts with him after the alleged choking incident? I mean, does that
I'm
somehow
not aware
show
of-
that she did consent to continue all of this? I don't know.
I'm not aware of any case saying that, and I think the gravamen of affirmative consent is that the consent needs to be knowing, willing. There needs to be clear permission. There needs to be clear permission for each sexual act. It's a different world than all of us grew up in. But that's what the student handbook teaches. That's what students are taught when they enter the university, and that's what's required. And
Okay, well, I have a question about the burden shifting. Do you believe there was burden shifting in this case?
no, there was no burden shifting in this case because, again, as I've identified, there was evidence from her testimony, from the Title IX complaint, from his Facebook messages, quote, I was drunk and horny and let my monkey brain have fun in the moment. I wouldn't have hurt her nor broken.
Into the mic.
There's evidence from the Facebook messages. There's
I want to
evidence.
get back to those messages because you have something in the middle there that you included, and it was actually 2:52 a.m. I'm okay. On page 229.
Page 229.
In the middle of the page, Sunday, September 8th, 2:52 p.m. I hope you're okay.
Yes, that is a text message from her friend, SK, so not the complainant, to the complainant.
At 2:52, while all this was going on.
No, PM, the afternoon after this occurred.
September 8th, 2:52 p.m.
Yeah, so this is in the afternoon after the events occurred.
Okay.
I believe that, and I appreciate that Your Honor is familiar with the record, and I'm very deeply sorry for any implication otherwise. But as Your Honor knows, that her friend picked her up afterwards. The two of them went to the beach. They discussed the incident. They cleaned out her car
That she was not intoxicated.
at I think it's around 5 a.m. Yes, but again, intoxication is not was
an issue here.
not an issue
Anything else,
in this
Ms.
case. I just want to point out extremely briefly that although his brief said that this will remain with him the rest of his life, the student handbook states that 5 years from the suspension. You can apply to have the notation removed from your record. And representing the university here today, if he completes the one-page paper, there's no reason the university would not remove the notation. So he can apply to have the notation removed in fewer than 2 years from now, February 2025. So I just did want to clear up that one piece. Thank you.